Resuming debate, reprise de débat, the honourable member for Calgary-Shepherd.
Thank you, Madam Speaker. So I'm glad to be up on my side as the first member of the official opposition to rise on C-71. And after hearing the minister speak on this, it tells me that there's a member there who just came here unprepared to actually deal with the substance of the legislation, the substance of the legislation that he himself tabled in this House. So first of all, just to debunk a bunch of things that were said that are actually incorrect. They're not true. If you look at the record, Madam Speaker, like I said in my question, on February 15th, 2008, and on Thursday, February 7th, 2008, in the original debate on C-37, on the first generation limit, that introduced the rules that existed between 2009 and until the end of 2023, when Ontario Superior Court ruled that there were 2 charter violations. The Liberal Party of Canada voted for it. They supported a motion to continue forward with the legislation at the next stage. Twice, not once, where you could perhaps say they weren't paying attention, but they did it twice. They accepted the logic of it. And I want to show you, Madam Speaker, that not only did they accept the logic of it, there is a report from a 2005 Immigration Committee that actually recommended doing something like a first-generation limit rule into legislation. 2005 was when Prime Minister Paul Martin was in charge, which means that it was a minority government, and the majority on the committee decided to push forward on that recommendation, which was then adopted in 2007 by Diane Finley, who was the immigration minister at the time. So this ridiculous claim that we on this side are taking away rights or that rights are being taken away is absolutely false. They all support, in fact, even the NDP supported that motion at the time. There are some members sitting here today who were in their seats at the time when they supported that C-37 motion, not once, but twice. So let's start with that. Nobody is losing their citizenship through this legislation. That is not what we're talking about. Conservatives believe that everybody has a right, if they meet the rules, to apply for citizenship. But new rules are being created here for citizenship by descent with a substantive connection clause that the judge said was necessary. We disagree with how the substantive connection test is created and what the rules are for it. That is a substantive reason to oppose this legislation at second reading, something that all the other parties knew about, because as the minister mentioned, we were going through this during the S-245 debate. Now again, I think I've shown that this is not anything new. Other parties supported the first generation limit at the time. They were all on side to push through C-37. And in our belief is that Canadians like myself, who are naturalized Canadians, are treated exactly the same in the Citizenship Act and the law as Canadians who are born here. My children are born here. I'm a naturalized Canadian. We are considered Generation Zero for the purposes of current legislation. In fact, I'm not the only one saying that. That's the judge saying it in Section 9. So he says Gen Zero, the applicants belonging to Gen Zero are Canadian-born citizens who had children abroad or naturalized Canadian citizens who had children abroad after their naturalization and whose children acquired Canadian citizenship automatically by descent. This is really what we're talking about is grandkids. And the critical question that government officials have been incapable of answering, and I think we would want the sound logistical planning, the words that the minister used himself just now. Sound logistical planning would indicate when you're passing legislation, proposing it to the House, that the House, the members, should know how many people will be affected by it. How many people will be included? Because this is about the grandkids who are born abroad to parents who are abroad when they get citizenship by descent. That is the critical question here. And they haven't been able to answer that, Madam Speaker. They haven't been able to answer how many people would this apply to. And I would think that all the benefits that we give out to Canadian citizens that this Parliament has voted on, transfer payments that we allow, the ability to travel on a Canadian passport, one of the strongest passports in the world, the ability to be evacuated from certain countries when there are issues and problems overseas, like we saw during the pandemic. You would think that this government would take the summer to do their homework. Yep. And the minister didn't do their homework. Instead, he came here to accuse Conservatives, accuse anybody who disagreed with him, frankly, did not even read the record from 2008 to know that his own party voted for it. They were in support of it. The same rule that the Superior Court in Ontario found, for 2 reasons, is not charter compliant. Well, I believe that that should have resulted in an appeal to the Supreme Court of Canada. On a matter as important as the Citizenship Act, I would have liked to have seen the government appeal it. The Minister of Immigration refused to explain to the House why he did not seek that appeal, why he chose not to go forward. Now, one of the reasons, and it's found later in the ruling, and I'm going to read from the ruling partially, Madam Speaker, because I think it's important. One of the reasons that the legislation was found to be not charter compliant is a bureaucratic incompetence at the Immigration Department. And that is entirely on the back of the minister. He is responsible for the logistical planning, those are his words, to make sure there is no backlog, that applications have the correct information in them, that officials are held accountable. So I'm going to read from section 263 to 265, different parts here. So the judge noted, on cross-examination, he testified that his source for this information were various unnamed IRCC case managers. However, the information Mr. Millard obtained from these case managers was replete with inaccuracies. With respect to Mrs. Murayama, these include misidentifying the year Mrs. Murayama's father was naturalized as a Canadian citizen, Mrs. Murayama's mother's citizenship, the reason for rejection of Mrs. Murayama's children's application for permanent residency. Now, there are also errors in Mr. Miller's evidence about how Mr. Chandler's child acquired Irish citizenship. Paragraph 264. I note that in addition to these errors, at the outset of the hearing, I was advised that Mr. Burgess had been told that his child, QR, so this is to hide the identity of minors, had been granted permanent residency or citizenship status. However, counsel for Mr. Burgess was unable to confirm exactly what was going on because, in the mail, the Burgess family had received citizenship documents pertaining to someone else entirely, unrelated to the family or the application. In paragraph 265, the judge, again, found in a very small sampling that there was an error rate of 50% in these particular case files. Now, I think many of us in our constituency offices back in our ridings, about 80 to 90% of our work now is immigration case files. I hope members will agree with me that we find replete errors time and time and time again. Because of the errors on the bureaucratic side that this minister at his department that he runs, that he's responsible for, his minister accountability for, the judge found that there were charter violations. That is not a problem with the original idea that the Liberal Party of Canada supported. I'm going to repeat that to them. They supported it not once by accident, but twice. They knew exactly what they were doing at the time. Now, the minister talked about the substantive connection test without referring it to directly, saying that there would be a 3-year naturalization limit. Now, that is an incomplete statement. It's an incomplete answer. That suggestion to use the same rule that we have for permanent residency is the one found in applications for permanent residence to Canada, 3 out of 5. So I don't think that is enough. I've made that case before at the Immigration Committee during the S245 debate. And the reason I don't believe it's enough is because of the way it's going to be calculated. So the way the rule will be applied here is if the parent of the child could demonstrate 1,095 days in Canada, non-consecutive at any time before the birth of the child. If you're having children later in life, you will have more time to prove that 1,095 days to pass on your citizenship by descent. So by descent here. If you ever traveled back to Canada, you could obviously give birth to your children in Canada. As a Canadian by descent, you could do that here, and they have birthright citizenship, just like my children do when they were born in Calgary. All of them, all 4 of them were born in Calgary. The 1,095 days also, when we proposed to make it consecutive so they could prove a substantial connection to Canada. And I thought 3 years, we agreed at committee amongst conservatives, 3 years seemed like a reasonable amount. You went through a K-12 system, you went to school for a few years, and then your parents left Canada for whatever reason, for work opportunities, take a year off, whatever it is, that 3 years consecutive would be a good demonstration of a substantial connection to Canada. That was voted down by the Liberals. In fact, they voted down nearly, I think, all of our amendments. We proposed over 40 of them. And let it not be said that we're not reasonable. We actually voted with the Liberals on 10 of their amendments. That we said, you know, we can see the wisdom of it. There are sections in C-71 we agree with, treating adopted children of Canadians equally to those who are naturalized or born Canadians. We agree. That seems like a reasonable thing to do. The faster revocation rules for citizenship, if you don't want your citizenship and you want to give it up, We agree. It should be a simpler process. The example that the minister gave, again, it's an incomplete example. The best example to give would be for those members of parliament serving in the Australian parliament, they actually cannot be dual citizen. It's directly under our constitution. So in order to not have certain members who might have Canadian citizenship eligibility by descent, you not want to make them ineligible. I know in my case, I am a dual citizen. I'm a citizen of Canada by naturalization, and I'm a citizen of the Republic of Poland by birth. Now, they would charge me about $565 to give up my citizenship, and I am not giving up 1 red cent. There are still some red cents in circulation. I will not give up 1 red cent to the Republic to have to pay them to give up my citizenship, and the application is entirely in Polish as well. Our rules actually be much simpler for individuals to be able to renounce their citizenship if they did not want it. I find it interesting that the minister didn't even know that about his own legislation. We also support another important part, which was in the original S-245, this Senate bill that came from our colleague on the Conservative side, Senator Yona Martin. So Senator Martin wanted to address 50 months of lost Canadians between 1977 and about 1981. We agreed. That's why the legislation came here. And at the time we said, can't we just pass this quickly enough to look after the Section 8 lost Canadians? Because we agreed that they should have their citizenship restored because they missed the cutoff date. In fact, one of our members from Saskatchewan almost became one of those lost Canadians, and he only found out in a few months' time that he needed to actually apply to maintain his citizenship. So we agreed with the principle that that group of Canadians should have their citizenship restored, protected. Now, the other changes that the government's proposing in here is not what I would call proper planning, proper logistical planning, to use the minister's term. And why should we believe that this minister would be capable of managing the new applications that will result of people seeking the proof of citizenship document? That's why I asked the question, how many people will this be? How much resources are needed to process these? Are they in the thousands, tens of thousands, hundreds of thousands? Are they more than that? That would be a huge burden on the department. Back in September of 2022, that minister announced that they would have all digital applications, and the claim was made both in public and private in that committee that it would help reduce the backlog of immigration applications. It hasn't done that, Madam Speaker. We're still at over 2 million backlogged applications in the system, and some of the wait times are just as long, if not longer, than they used to be for some of the major PR programs. I'll read you a few of the headlines from different commentators, immigration consultants on this. So the first one is here from Law 360 Canada. Bill C-71 depreciates Canadian citizenship by Sergio Arcaris. First reading, how the Liberals keep dropping the barriers on who can become a Canadian. Jamie Sarkonik. Liberals water down citizenship for grandkids of convenience Canadians. Government bill will allow Canadians to pass citizenship rights to kids born abroad. This is a Canadian Press article. Another one here from Brian Lilly. Trudeau Liberals making moves to cheapen Canadian citizenship. Canada introduces new bill, it says, to restore citizenship by descent. And then if you go into the provisions on this substantial connection test, on which I have, again, a lot of concerns. At committee, we proposed a change to make it consecutive days, 1,095 consecutive days.
Point of order, the honourable member for Thérèse de Blainville. Is there a hard time with the interpretation?
Is it working now? Is it working now? I'll keep talking.
Oui.
Is the translation working? No?
Je sais pas, Madame la Présidente.
I'm not sure, Madame Speaker, you were the one speaking in French. I thought there was a problem with the translation. That's why I was speaking in English to see if it was working in French.
Is it working now? Testing. Okay, oui.
Oui.
C'est bien. Okay, and I just want to remind the honourable member, he was reading titles and he mentioned the Prime Minister's name, so I would just ask him maybe to just say Prime Minister as opposed to the name. The honourable for Calgary Shepherd.
Thank you, Madam Speaker. Forgive me for that error if I read the Prime Minister's name into the record. I don't believe I did. So, yeah, forgive me for that, Madam Speaker, and thank you for reproaching me for doing so. Peut-être je vais donner un break.
Perhaps I will give the interpreter a break and continue in French because I see that I have roughly 6 minutes left to speak about the backlog of applications at the Immigration Department. We always forget that it's immigration and citizenship, that there's two things there at the same time. So all of the backlogged applications, well, there's more than 2 million of them. And this minister is insisting he's working on them. He spends a lot of time on Twitter, on X, battling with anonymous people and taking cheap shots at those who don't agree with him, rather than managing his department. And we see this a lot at committees, at the Immigration Committee. There are many people with this backlog of applications. Some people wait 2, 3, 4, 5 years, sometimes even, for applications that should be easy to complete in the deadlines that are given. And now we're seeing this today. We'll have a look at the refugee situation, the management of this government, and by this minister in particular. Well, what we've seen at the department today, more than 220,000 asylum seekers that are in the backlog, more than 300,000 that are waiting, and now there's a 3.5-year wait before a request can be processed, examined, and for an answer to be applied. So in 2016, it was estimated at roughly 17,000. So we went from 17,000 for asylum seekers to 220,000 backlogged files, and more than 100,000 files that are in processing. So thousands of people are waiting, people who came to Canada under another immigration program or went through Roxham Road. They made an asylum request or a refugee request, and we thought that the government would have given enough resources to manage these people who go through the system to make sure that their rights are not violated. And that's what the minister has said here. But now we're seeing year after year, it continues. I even have the figures. In 2022, when the minister became the Minister of Immigration, it was over 60,000 backlog. In 2023, the backlog went to over 150,000, and then in 2024, in July alone, we're over 200,000 backlogged files. And now I made an ATIP request that I received the answer to today that shows that more than 18% of people who make a request for an asylum application, 18% of international students, they're international students, and they are now in this backlog in this department.
When the minister's talking about, he doesn't know the numbers, couldn't respond to the question, this is critical to how immigration and citizenship and the refugee system is managed in Canada. The minister doesn't know the impact of his own legislation. And that greatly worries me, that he's not aware of the details. And like I've demonstrated, we Conservatives had a private member's bill that was proposed from the Senate side that offered to fix the Lost Canadians for Section 8 Lost Canadians, those 50 months. We were on side. We proposed substantive amendments once the scope of amendments was expanded to the substantive connection test, and to introduce what I think is the most critical requirement to have a police record check, to actually do a security record check. One amendment, I will say, that the Liberals voted against, with their allies in the NDP, voted against it at committee. And now we've seen over the last 6 to 12 months many security issues with different types of visa applicants who have been approved and come to Canada. I think the security of Canadians is incredibly important. The integrity of our citizenship system is critical. And I don't trust this minister. I don't trust the Liberal Party. I don't trust their allies in the NDP either, that they will be able to manage the new flow of applications, because they just don't know how many people will be eligible through C-71 for citizenship by descent. And as the judge found in his own ruling, the reasons for the charter non-compliance is not that there was an overall violation for it. It was because of the incompetence of the minister, the bureaucracy that was failing to provide accurate information. Madam Speaker, 50% errors in applications being processed. Dates were wrong, names were wrong, even they received a citizenship document for someone who wasn't even related to the same family. Those are serious errors in administration that the minister should have had fixed. So we will be opposing this piece of legislation. We will then propose amendments, because we're going to seek those amendments at committee to try and fix the legislation. And if we can fix it, then we'll revise our position. Because I think if we can fix it by providing the substantive connection test be 1,095 days consecutive or more days, we can come to some type of agreement on what Canadians expect. And a security record check is an absolute requirement. We have already chaos in the immigration system. The immigration minister and the government that he's part of has destroyed the consensus in Canada that immigration is a great thing. And I think it is a great thing. I'm just sad to see so many Canadians come up to me during door knocking at town halls they don't agree with anymore. So because we can't trust them with something as important as our citizenship, we're going to vote against them.
Great job.